Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're back to one of my favorite cases, the Murdaugh case, and let's take a look at a couple of things related to this most recent motion, and I'll give you my thoughts on where this is going. So, first of all, the motion wasn't made in Colleton County. It was made in the Court of Appeals. The way it works in every state, as far as I'm aware, is that once the trial court renders its verdict and issues its judgment, it usually has 30 days in which to reconsider that judgment. Sometimes it's longer, sometimes it's 45. And if a motion for new trial is filed at that time, then, at least in Missouri, the court has 90 days to consider it, and if it doesn't rule on it before the 90 days, then it's considered denied as a matter of law. In most cases, judges rule on them fairly quickly and with a one-line order that says something to the effect of the motion for new trial is overruled. But once that happens, once that motion for new trial is overruled, and once the time period in which the court has jurisdiction to alter its judgment is over, then the next thing that happens is if you're going to file an appeal, you have so many days to file it. And once you file that appeal, jurisdiction then vests in the Court of Appeals. The Court of Appeals is an appellate court. It is not a fact-finding court. It is not a fact-finding court because they do not have the ability to impanel a jury. They do not have people there to conduct trials. They are there to rule on motions and appeals. So that's what's behind this particular motion right here. Hey, if you're enjoying this content, please feel free to like and subscribe. It really helps the channel and makes it possible for me to continue to do this. That's it. That's the commercial. This is the motion to suspend appeal and leave for motion to file a new trial. Now, the appellate court has not ruled on this motion to this point, and they will have to rule on it before Murdaugh's lawyers can file their motion for a new trial. But to give the court something to think about in terms of granting this motion to suspend the appeal, the Murdaugh lawyers thoughtfully provided a copy of what will be their motion for new trial. I'll go over this briefly and then we'll discuss some things. By essentially what the claim is that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Specifically, during the trial, the court clerk instructed jurors not to be misled by the evidence presented in Murdaugh's defense. She told jurors not to be fooled by Murdaugh's testimony. I can't believe that any of the jurors needed to be told that. And during the trial, Ms. Hill asked jurors for their opinions about his guilt or innocence and supposedly invented a story about a Facebook post in order to remove a juror that she thought was favorable to the defense. She pressured jurors to reach a quick verdict, telling them at the outset of their deliberations that it shouldn't take long. And although I didn't see it in here, one of the things that they allege is that she would not allow them to go out on smoke breaks after the jury was set to deliberate. Now that may be a local court rule. It may not be something that is in any way related to her pressuring the jury, but that's what they're alleging. They also allege that she did this to secure herself a book deal, which is kind of ridiculous since she's self-published. And if you've ever self-published, and that's something I have done, you know that you don't wind up making a ton of money off that. Basically, you publish your book, and if people buy it, great, and if they don't, well, that's okay too. I don't believe she did this to make a ton of money for herself. I think she just basically wanted to tell her story. So they say she betrayed her oath of office. Some of the statements that are sort of attributed to her include, y'all are going to hear things that will throw you off. Don't let this distract you or mislead you. Ms. Hill even instructed jurors they could not ask the foreperson about her private conversations with that juror. And she told jurors not to be fooled by evidence that Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. So, according to Ms. Hill, a subordinate employee in the clerk's office discovered that a post was taken down and replaced with an apology, apparently by a guy by the name of Tim Stone. There was a juror with the last name of Stone on the jury, and Tim Stone was her ex-husband. Apparently there were two Tim Stones, and that caused this particular issue. As a result of that, the judge wound up removing that juror, and they are crying foul about that. But here's something really interesting. They talk about this sworn statement that he supposedly never made such posts, and it says, Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd through March 2nd, which confirms he did not post the apology. But then, in parentheses, it says this: the supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policies. Thus, they can't prove that he did not make that post. And that, I think, is a real problem for their motion here. So that's sort of their motion in a nutshell. Now, what I want to talk about is the press conference that Harpootlian and Griffin held to announce this motion being filed. Now, generally speaking, I don't know of any lawyer in the civil arena who has ever gone to the media and announced that they are filing a motion for new trial. I don't know of any criminal defendant, in my experience, going to the media and announcing that they're going to file a motion for new trial. Generally speaking, attorneys try their cases in the court of law, not in a court of public opinion. But apparently, the most dangerous 10 feet in America is between Dick Harpootlian and a television camera. And I think probably the same thing can be said for Jim Griffin. They both like the limelight, and they love to get up and pontificate in front of the media. These are my opinions. I believe that the press conference bears this out. Why is this important? Well, let's take a look at the rule that is effective in this particular case. This is the ABA rule, Rule 3.6. It's not the South Carolina rule. The South Carolina rule may have small modifications in it, but generally speaking, it will be pretty much this rule. And here is what it says. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Now, that to me seems pretty clear. It's designed, I think, to prevent juries from being subjected, or I should say the entire jury pool, being subjected to a lot of pretrial publicity that tends to sway opinions. And that's why this rule is in place. But you have to remember, when they did this motion and they did this press conference, the only people with a right to make a determination at this point is the Court of Appeals. So it seems to me that a lot of what they said during their press conference, and I'm not going to show video of that because, frankly, I don't want to assist them in any way in making their case, which I think is ridiculous. But basically, you can't get up and make statements that you know are likely to prejudice an adjudicative proceeding. Now, among the things that I found absolutely amazing in this press conference, Dick Harpootlian asked the media to respect Mr. Murdaugh's privacy, at the same time that he gets up and goes through this entire rigmarole with apparently two jurors who were upset that this clerk, Becky Hill, wrote her book and published her book. Now, I think it was very unwise of the clerk to publish a book. There are just some things that you should keep under your hat. And particularly when you've been involved in a high-profile case like this, the only time to bring in any or to do anything like writing a book is well after the appeal is over and after Mr. Murdaugh is safely ensconced in the South Carolina prison system. But that isn't what she did. She wrote this book, and apparently it upset some of the jurors. And at least 2 of them were responsive to requests by the defense. Now, the defense in this motion or in this press conference said, we knocked on a lot of doors, had a lot of doors slammed in our face. There was a cone of silence around this. Yeah, that's because you're not supposed to harass jurors after a trial. You can ask to speak to them, and if they choose to speak to you, that's fine. If they don't choose to speak to you, you have to leave them alone. Well, then after this book came out, according to them, these jurors came to them. I don't know that that will be revealed in the course of the investigation. One of the things that I thought was especially bad was Harpootlian made a number of derogatory comments about the SLED investigators. And let's look at what the rule says about that. Now, they can talk about the defense involved. All right, we filed a motion for new trial. We're going to claim that the clerk tampered with the jury. They can say that. They can say that an investigation is in progress, and indeed it is, by the South Carolina Law Enforcement Division. And they can say things like, a reasonable lawyer would believe was necessary to protect a client from substantial undue prejudicial effect of recent publicity. Well, there wasn't any recent publicity. So that is the rule. All ABA rules come with a comment, and here is the trial publicity comment. One of the things they say is it's difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. Preserving the right to a free trial entails some curtailment of the information that can be disseminated about a party prior to trial, particularly where a jury is involved. Well, at this point, no jury is involved, but there are still limits on what a lawyer can say. On the other hand, there are vital social interests served by free dissemination of information about legal consequences and legal proceedings. The public has a right to know if there are threats to safety and measures aimed at assuring their safety. That's, again, not at issue here. It also has a legitimate interest in the conduct of judicial proceedings. Okay, now, I do think they have a legitimate interest in the conduct of judicial proceedings, but that doesn't mean you can go into the level of detail that they went into in this press conference. I think it was really very wrong. The rule sets forth basic general prohibition against a lawyer making statements the lawyer knows or should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. The rule only applies to lawyers who are or who have been involved in investigation or litigation of a case and their associates. So someone like me, it doesn't apply to. I can opine on that case all I want to because I'm not involved. I don't have standing to be influenced by this rule. Even with that, I try very hard to, during an adjudicative proceeding, to keep my comments aimed at trial tactics and not so much at the credibility of witnesses. But one of the things that they do say is there are certain subjects that are more likely than not to have a material prejudicial effect. And one of those is the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness. And in this particular case, Dick Harpootlian made a number of comments about the SLED investigator that was involved in the original case. Now, all of that stuff came in during cross-examination. And so when you're out there talking about this now, it looks to me like you are trying to pre-prejudice any veneer in a case later on. And I think that Harpootlian has got a really hard hill to climb if there ever is another new trial. I think he's got a really difficult hill to climb, in large part because people saw that trial, everybody talked about that trial, and everybody is aware not only of the evidence that was presented, but of the evidence that was excluded. And I think at the end of the day, you're going to have a really hard time, A, impaneling a jury, and B, impaneling a jury that hasn't already formed some kind of conclusions about Murdaugh's guilt or innocence. I think that would be a very difficult thing to do. Obviously, if there's a new trial, they have to do that. Let's talk about what's at stake here. What's at stake here, at least from my standpoint, is the sanctity of the trial process. If Ms. Hill made comments that were intended to sway the jury, and at this point, I don't know that she did. Now, what she said, I don't think, if it's true what these jurors have related, and again, you have to take all of this with a grain of salt because those affidavits were not written by the people who signed them. Those affidavits were written by the attorneys representing Mr. Murdaugh. And I've written a few affidavits in my time, and I have always tried to phrase things in the way that was most beneficial to my client, but that was still the truth. And we have to hope that that's what they've done here, but all of these people are going to be subject to cross-examination. And at the end of the day, it doesn't matter if it swayed their verdict or not. In other words, you could have the juror get up and say, oh yeah, she told me that, I shouldn't believe Alec Murdaugh, but heck, I already knew that. The guy's a liar. If indeed that happens, that does not cure the problem. In other words, the fact that the jury would have reached the same result in the same time period, irrespective of what Ms. Hill allegedly said, that doesn't create an exception to the rule that he is due a new trial, because the trial process was corrupted. There are a few things that are more important than a jury trial and a jury having a right to deliberate without outside influences. You've got 12 people, you've got 12 different perceptions of the information that was presented during the trial. People have to sit down, talk out any differences, and reach a conclusion. And if they can do that, then that's great. And if they can't, then you mistry the case and you do it all over again. Here's the bottom line. I think the issue here, I think the strategy here is not to actually get him a new trial. I think the strategy here is to, one, provide an additional grounds for relief by appeal and get a new trial that way. And two, I think the strategy is, if they are able to get the judgment reversed and a new trial granted, that Murdaugh will do, as he has done in these financial crimes, plead guilty to perhaps second-degree murder. The bottom line is he will say things that are necessary to get him a second-degree murder conviction so that he will do a definitive term in prison, 30, 40, 50 years, whatever it is, under South Carolina law, that he can then serve concurrently with his other financial crimes, which means that in 30 years or so, he could potentially be free. I think that is the goal here. But I think if that's the goal, they have badly miscalculated the degree to which the Attorney General wants Alec Murdaugh in South Carolina prison system. I believe that Creighton Waters and the South Carolina Attorney General will pursue this thing with vigor, and I believe there will be a second trial if that happens, and I believe the result will be absolutely the same. I think the comments by Dick Harpootlian were improper. I think they violated the rule. And if I was in South Carolina, I would file a bar complaint against him for what he did. In many respects, going after these jurors, pounding on their doors on Sunday afternoons, as he clearly spoke about doing in this press conference, I think that is going much too far. I think it's harassment of those jurors. And I think they pursued this with a goal in mind. I think his comments were inappropriate, particularly as to the sled investigator. And I think that Creighton Waters has a really good basis for a motion to disqualify him based on his extrajudicial statements about the investigator. simply because it doesn't look to me like he was doing anything other than seeding doubt in the jury pool. And you can't do that. We'll see what happens. I don't know for sure that the court will grant this motion, but what I suspect is there will be an evidentiary hearing. The judge will oversee this evidentiary hearing. I think you can ignore the idea that the judge is going to be a witness, because the judge wasn't a witness to any of these interactions. The only thing the judge said was, I don't think Ms. Hill should have talked to the juror by herself. She should have brought the juror to the judge, and I think that's absolutely true. But he is not going to be a witness in the form of a necessary witness. He may very well be a witness, but that does not disqualify him. Again, I think they are after a way to get him off the case so that they can get a judge perhaps who might be a little bit more lenient. You have to understand that both Murdaugh and Harpootlian know how to play the political game, and the political game in South Carolina is pretty important to everybody who plays it. I offer that just for my observations about where this is going. So hopefully this has been illustrative of the issues that are at the heart of this particular motion and case. I would give them probably 60-40. There's probably a 60% chance they're going to get a evidentiary hearing. And if the evidence comes in as they've presented it without significant eradication on cross-examination, then they're probably going to get a new trial. But again, he'll stay in prison because he just pleaded guilty. And basically what he wants to do is be in a federal prison, not in a state prison. But you got to be careful about what you wish for, because he could very easily wind up in a high security prison like the one in Atlanta, which is not a very nice place. I'm sure what he would love to do is be in one of the federal prison camps like they have at Maxwell Air Force Base in Montgomery, or other places all throughout the South. Some of those prison camps are just really dormitory kind of living conditions and wouldn't be hard time at all. South Carolina, however, the prison system is hard time. They just recently took away all of Alex's, visitor or whatever phone privileges, I think is what they took away, because he violated their rules by making public statements from prison. So that's what I have for you. Hopefully, you found this interesting, helpful. If you have the opportunity today, please do something nice for someone. And join me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.